in one way, it's like, oh no, if it went away in this case and the conduct wasn't directed at a particular person in the Chauvin case, George Floyd, oh no, what if it goes away? But here, there's that added protection of the second-degree murder charge. Let's not forget, he was convicted of something higher than Mohamed Noor was. So at the end of the day, to me, it seems it's not really going to make a difference. Even if it does go away to Derek Chauvin, they've got the higher charge and the lesser ones still. Your thoughts on that, please?
I agree with you on that, but what this case brings to mind is a discussion we had about disparity in sentencing. How in this case, the officer received 57 months, and in the other case we talked about a sentence the defendant received that I thought was too low, and we had this discussion about the law in particular states, and I think this kind of highlights sentencing guidelines, and to make sure everyone understands, certain states follow the federal system where for every crime, there are statutory guidelines that list factors that must be taken into account for a particular defendant, his crime, his background, prior convictions, and they're given point values, and you come up with a number, and that is, gives you a range of time or sentencing time that the person will receive, and the judge has very little discretion. Versus states like South Carolina, where I live and practice law, where you have offenses that carry 0 to 25 years, where a judge can give you anywhere from 0 to 25 years, and there's no real rhyme or reason to it except for a judge's personal biases. In this particular case, Minnesota is like the minority of states that follows the federal rules, and they have a set of sentencing guidelines. And based on the sentencing guidelines, whether anyone believes that his sentence was too light or too harsh, he received a sentence at the maximum of the guideline range. He actually received the maximum sentence in that case, which is 57 months. So I think this case highlights issues and concerns about disparity in sentencing around the country and the importance of maybe considering guidelines across the board.
I agree, John. And I think that maybe revisiting the statute and amending it so the language is a little better. I misspoke earlier. It wasn't the court that called it a poorly written law. It was the victim's parents, Justine Damon's parents, who said that. And I do agree with them that it is. I mean, when you have third-degree murder and it's saying the conduct has to be exhibiting a generalized indifference to human life, not directed at a particular person here. And we know there was a lot of discussion about this back and forth in the Chauvin case. I mean, we remember that at the prelim, the court in that case in Minneapolis had kicked to that charge because it really didn't fit the statute. And then because the appellate court said, no, it applies in Noor, then it had to be added back on. And now we see the Supreme Court saying, no, actually, it doesn't fit in Noor, and so it goes away. And what a mess. I mean, I think the legislators need to do their job and fix this so that the prosecutors can properly use it in court.
Well, I just think that's just the nature of every state's laws. I mean, South Carolina has laws regarding general intent versus specific intent. And I think there are circumstances where it would be reasonable to have a difference and distinguish between the two. I think making a change to the law because the victim's family or even the defendant's family doesn't like the outcome, I think that's just a bad idea, because you start trying to tailor the law to get the outcome that you want in a particular case. And clearly, in most cases, the legislator took a fair amount of thought into, making this distinction in the law. And there are certain cases where I believe under different facts, it would have been the right thing to do. So I'm just always concerned when you have, once again, victims, victims' families that want to change the law because they don't like the outcome in their particular case.